Good afternoon, everyone. Welcome to the Tuesday, not Monday, Tuesday webinar. It does feel like Monday for me. I'm sure it does for many of you. I hope everyone had a lovely long weekend for Labor Day yesterday. So today I wanted to start out with a plug for our fall breakfast briefing. I guess now we are, although not technically fall, it sort of is like fall. So we're going to talk about our fall breakfast briefing, which will be coming up in these 13 cities. I haven't figured out a way to put a link in here for you to register, but just type in bsk.com/events, and the link for signing up for the event. The in-person event will be on our website. So hope to have many of you there in attendance at this presentation coming up pretty soon. So with that, let's move on to today's agenda. Today's agenda is local for me. It's all attorneys in our local Syracuse Labor Department, people who are all on my floor here with me. So I'm happy to see all of you, and thank you all for being here to present. Just quickly, I'll just run down. We've got Hannah Redmond, an associate in our Syracuse Labor Department, who's going to talk about this Freelance Isn't Free Act. You may have seen an information memo that we wrote, that Hannah wrote, go out recently. We talked about this at our client seminar back in the spring, but it wasn't yet in effect, but now it is. So it's a good time to get a reminder about the Freelance Isn't Free Act. And then next we're going to move to Colin Leonard. So last week we had Travis Tellerico here talking about political speech in the workplace, heading into this fall presidential election season. And I got some questions from some of you out there who are in the public sector. And so thought we would just do a part 2 today that talks about the public sector. Even if you're not a public sector employer, I think this is just interesting to know, how those who work in the government have sort of a different set of protections. And also thought, I know we have a lot of attendees and clients in the nonprofit sector, and just wanted to touch on a different angle of the issue for them as well. So Colin's going to cover that. Next up, we have Subha Viswanathan here again in our Syracuse office in the Labor Department, talking about record keeping obligations. I always appreciate Subha when you're here. Subha's a very regular contributor on wage and hour issues. And so this one is another important one. Even if you're paying employees correctly, I think this is going to be a theme, Subha. Even if you're paying people correctly, if you're not keeping the records, you could get into some trouble just for that. And then finally, Nick is also a regular contributor, coming here about once a month these days to give us a litigation update. So Nick's back here again today with another case that recently was decided and is of some interest. So I'll let him tell you the details. So with that, let's get started with Hannah.
Thanks, Kristen. Can we go to the next slide, Kathy? All right, so good afternoon, everyone. Really happy to be here. As Kristen mentioned, I'm going to be talking about the Freelance Isn't Free Act. This law was originally going to be codified under the New York labor law, but was amended before it became effective, and it now lives in Article 44A of the General Business Law. As Kristen noted, this law is now effective. It just became effective last week on August 28th, so hopefully this is a good refresher for everyone as we gear up to become compliant and make sure we're following the requirements of the Freelance Isn't Free Act. This is statewide legislation, but for those of you who are in New York City or have operations in New York City, you may be familiar with a lot of the requirements of the statewide legislation because it was modeled very closely after New York City's Freelance Isn't Free law. In fact, a lot of the provisions parrot New York City's law verbatim. The purpose of the act is to first provide recourse to freelance workers who experience wage theft and other violations of labor law, and also to ensure that they receive timely payment for any services that they're providing to a hiring party. Next slide, please, Kathy. Thank you. All right, so we have two main definitions to worry about when we're talking about the Freelance Isn't Free Act. The first is a freelance worker. As you can see from the definition on this slide, it's a pretty bulky, verbose definition, but a freelance worker is essentially any person or sole proprietor who provides services of more than $800 to a hiring party as part of a one-time transaction or as a series of transactions with the same hiring party in the preceding 120 days. There are several exclusions from this definition, including attorneys, licensed medical professionals, construction contractors, and then certain sales representatives. And that is a specific sales representative as defined by Labor Law 191A. And then a hiring party is any person who retains a freelance worker to provide any services, but excludes any government entities. So any local, state, or federal governments. The definition of hiring party is extremely broad. So virtually any individual, any organization, any business that hires freelance workers, gig workers, independent contractors needs to make sure that they're up to speed on the Act. Next slide, please, Kathy. The Act's requirements can really be broken out into two main subjects. And the first requirement, the first and probably the most significant requirement, is the requirement of a written contract. The hiring party has to reduce the agreement, the services agreement, to writing with the freelance worker. Contracts must include the names and mailing addresses of both the hiring party and the freelance worker. The contract has to reflect an itemization of all services that are to be provided by the freelance worker, the value of those services, and then the rate and method by which the service, the independent contractor, the freelance worker rather, will be compensated. The due date for payment has to be stated, or if there's a triggering event or another mechanism that's going to trigger the date for which payment is due, that needs to be specified in the contract. And the date by which the freelance worker has to provide a list of the services that were actually completed and provided must also be stated in the agreement. The New York State Department of Labor has published a model contract. It's available at the link on the slide here. You can also just Google the DOL model contract and it'll come right up. The contract does include more than is required under the statute, but given that it's published by the DOL, a best practice may be to use that standard model contract. Next slide, please. The Act specifically states that parties cannot contract around the Act requirements. So we're going to talk about timely payment. We're going to talk about anti-retaliation and anti-discrimination provisions that are stated in the statute. And the law is very clear that you can't exclude coverage of those things. So you can't waive the anti-discrimination provisions, you can't waive the anti-retaliation provisions, and you can't contract around the timely payment requirements that are otherwise required under the law. Those kinds of provisions will be void and unenforceable. The hiring party is required to provide a copy of the written contract to the freelance worker. So this is a little bit, we're reading between the lines a little bit here. The statute doesn't explicitly state that the obligation to provide the contract falls on the hiring party, but the way that the statute reads is it really is the burden of the hiring party to first and foremost make sure that a written contract is being executed, and then to provide a copy of the written contract to the freelance worker. Both parties are expected to retain a copy of that contract, but the statute is very specific in that it's the obligation of hiring parties to make sure that they're retaining that contract for 6 years. So again, we're seeing more emphasis, more burden being placed on the hiring party as opposed to the freelance worker, even though it's the freelance worker that's providing the services. Upon request, contracts have to be made available to the Attorney General, and failure to keep those records of any written contract for 6 years can come with significant consequences, because if the Attorney General does request a written contract and you haven't retained a copy and you can't provide the copy, there is a presumption that whatever terms the freelance worker is presenting as being the terms of the agreement between themselves and the hiring party, there's a presumption that those are actually the agreed upon terms. So that can carry significant consequences. Next slide, please. The second major requirement of the Act is timely payment. So we have written contract and then timely payment. Under the Act, timely payment means either the freelance worker is being paid on or before the date stated in the contract, or if the contract doesn't specify when payment is due, payment must be made within 30 days of completion of the freelance worker's services. Next slide, please. A third requirement, this is kind of self-explanatory, but the Act prohibits discrimination and retaliation against any freelance worker who enforces or attempts to exercise their rights under the Act. So you can't, decline to hire a freelance worker with whom you maybe have an ongoing or regular relationship because the freelance worker has contacted the Attorney General to raise a concern about their rights under the Act. So pretty self-explanatory. Next slide, please. And that brings us to enforcement. So there's two major enforcement mechanisms. The first is through the Attorney General's office. So the Attorney General is authorized to investigate violations of the Act or alleged violations of the Act. They can fashion remedies. They can bring an action on behalf of the state for injunctive relief to enjoin a hiring party from violating the Act further. And can obtain restitution for freelance workers whose rights have been violated under the Act. Next slide, please. The penalties for actions brought by the Attorney General include $1,000 for the first violation, $2,000 for a second violation, and $3,000 for a third or subsequent violation. That's the standard structure, the standard penalty structure. However, where there's evidence that there's a pattern or practice of violation, so if we have a case where a hiring party is a recurring character, right? We keep seeing complaints from freelance workers against the same hiring party, then the Attorney General is authorized to impose a penalty of up to $25,000. Kathy, I'm going to have you go to the next slide. The Act also creates a private right of action. So freelance workers who have had their rights violated or believe that their rights have been violated under the Act can bring a cause of action in court. The statute of limitations for those kinds of claims against hiring parties will depend on the nature of the alleged violation. So where there's a written contract violation, where the written contract was never executed or there was not retention of the contract, then the statute of limitations is 2 years. For other violations, including the timely payment requirement and the anti-discrimination and anti-retaliation provisions, the statute of limitations is significantly longer, and it goes all the way up to 6 years. I'm a little out of order here, Kathy. Can I have you go back to the last slide? So now that I've explained that there's both enforcement action through the Attorney General's office and a private cause of action, this last bullet here on this penalty slide captures the damages available to a plaintiff who pursues their rights independently by bringing a claim against a hiring party in court. And damages, again, depend on the nature of the alleged violation, but they include damages, injunctive relief, civil penalties, attorney's fees, and costs. And on damages, certain provisions allow for double damages. So there is significant possibility of liability here for certain kinds of violations. 2 slides now, Kathy. Thank you. Okay, so our main takeaways, we want to make sure that we're reviewing internal processes for engaging freelance workers, gig workers, independent contractors, service contractors, making sure really that we're familiar first and foremost with what the Act requires, but the most important requirement for individuals, organizations, businesses that are looking toward compliance is going to be making sure that you are reducing contracts to writing, that those contracts include those 4 main requirements. And then, of course, to make sure that any freelance worker or independent contractor is paid timely, either 30 days within 30 days of the completion of their services or as stated in the contract. And of course, we have a information memo online that sets forth all of this information. If you have any questions or curiosities around the Freelance Isn't Free Act, please do be sure to reach out.
Thanks, Hannah. It does seem that this is going to have somewhat of a broad application here.
Very broad.
I think if we take a second and think about, the ways in which we engage independent contractors in general, it's very broad. And, caught my attention when you said there's a private right of action with attorney's fees, because that changes the calculus there of anyone wanting to bring suit. I mean, it could be for a small amount, but yet worth a person's while to do that.
The fees become exactly what it's all about.
Okay. All right. Well, thanks so much for all that information. And we'll move on next to our next presenter, Colin, who is going to continue our discussion about political speech in the workplace. So thanks, Colin, for coming.
Thanks for having me, Kristen. Good afternoon, everyone. So as Kristen mentioned at the outset, last week, Travis Tallarico in our Rochester office spoke a little bit about political speech in the private sector workplace and outlined some of the contours of that area of the law. And we had some questions about applicability to the public sector. And we also had some questions about some not-for-profit questions that we wanted to talk about a little bit. And I would just say that some of what I'm going to talk about is public sector only, but I am going to include some a slide here where we're talking about applicability to both the private and the public sector here. So next slide, please, Kathy. So when we're talking about political or free speech in the public sector, we're always focused on this idea that public employers are unique because they have dual roles. So if you're a private sector employer in New York or any other state, you have a singular role. You are the employer of the employees who work for you. When you're a public employer, you serve dual roles, right? Your role is, of course, as the employer, where you have the same types of concerns that any other employer would have, private or otherwise, that you're trying to provide a workplace which is a place where you're getting the public's business done in an effective and efficient manner. And things like insubordination or not following the rules can be problematic to the efficient operations of that employer. But you're also playing a role as a government regulator, where you have to make decisions as the government in terms of enforcing the rights and privileges that come under the state and federal constitution. So you've got that dual role, and trying to play, or essentially a public employer is always trying to wear both hats and run correctly through what it can and can't do. Next slide. And of course, the tricky thing here is for a public employee also is playing dual roles here. Is the employee, again, doing the public's business in his or her role as a governmental worker, but also may have considerations as a citizen and have rights as a citizen. Just because they're employed by a governmental entity doesn't mean that their rights as a citizen have gone away. So that's been the tricky part in the public sector, is trying to figure out how an employee can do what he or she needs to do as an employee, but also where necessary or appropriate, express views, engage in conduct, speech, other forms of protected activity without running afoul of their responsibilities as an employee. Next slide, please, Kathy. So, the jurisprudence in this area has gone on for many, many years, but the first thing to understand is that just because this was in question at one point too, whether by becoming a public employee, you essentially forfeit your rights as a citizen. And the Supreme Court established in the 1968 case of Pickering that the First Amendment does protect public employees from retaliation where their speech relates to a matter of public concern, and the public interest in protecting the speech outweighs the governmental interest in operating effectively and efficiently. So when the Pickering case was decided, it dealt with the discipline of a public school teacher by the Board of Education, where the public school teacher was essentially had written a letter to the newspaper, essentially saying that the Board of Ed had gotten it wrong when they devoted a certain amount of money in the budget to athletics over academic affairs, and was disciplined for that. And the Supreme Court said, no, that was a public employee making a statement on the matter of public concern and concerning the budget. And that person's interests outweighed the governmental interest in trying to restrict that kind of speech so that it could operate effectively and efficiently. Next slide. Over the years, the Supreme Court and other courts have tried to give some guidance to how the public speech or political speech in the public sector really can work. And because it's difficult to know when exactly a matter is in the nature of public concern. So that second bullet point down below, right? Speech relating to a matter is a matter of public concern where it's political, social, or of other types of concern to the community. However, with respect to the first bullet point, where an employee is speaking pursuant to his or her official duties, even where it may touch upon a matter of public concern, is not going to be protected. And that's where the court said we have this obligation as employers and as courts to make sure that employees are engaging in their official duties. When engaging in their official duties, that conduct is not necessarily protected by the First Amendment, and they can be held accountable. So in the Garcetti case, that dealt with a law enforcement official who was writing a memo pursuant to his official duties as a law enforcement officer, which was critical of the law enforcement entity with which he was engaged. And because that memo had been written in the course of his or her official duties, it fell outside of the protection that the First Amendment can provides employees. So I think with respect to constitutional issues, when this crops up in my practice, typically we get a call or an email outlining the situation. I think it's one that is extremely fact intensive, because there are just so many criteria that might go into the analysis of whether it's a matter of public concern, whether it relates to the employee's official duties, whether when you engage in that balancing act, it is really going to be a tough call to make in certain circumstances. So balancing the employer's obligations or right to operate efficiently, effectively against the employee's right to make that type of speech. Typically, you should know these cases come up in courts through what's called the 1983 action, typically in federal court, where the employee makes a claim that his or her civil rights, including the First Amendment right to speech, was prohibited or was curtailed due to the employer's action. And in that situation, if that case is successful, they have the right to recover not only damages for the discipline or termination or whatever happened, but as well as attorney's fees. So it's really important to make sure before you're taking disciplinary action, even if it's a warning or suspension in the public sector, you're running through this analysis to see whether or not the conduct or speech may be protected. So if we go to the next slide, this is something that applies to both public and private sector entities in New York. And some of this was covered by Travis last week, so I'll go through it kind of quickly. But Travis did talk about this piece, which is the 201D, New York Labor Law 201D, which prohibits employers from discriminating against employees for off-duty, legal, political activities, and recreational activities. And this is what Travis talked about last week. But it's important to know that this is whether you're a public sector entity or a private sector entity, this can apply. If you could go to the next slide too, please, Kathy. Now, in 2023, there were 2 amendments added to 201D that I just wanted to make sure people had on their radar. Not sure this was covered last week, but these are 2 pieces that were added to the 201D prohibition. Again, both private and public sector protects an employee from discrimination or retaliation due to membership in a union or exercise of any rights protected under the Taylor Law. So if you're in the public sector, you've got maybe a union employee or a organizing campaign going on, or if you're in the private sector, same thing. If it's under the Taylor Law or under the National Labor Relations Act, be careful if you're taking action because the employee has engaged in some form of protected activity under the Taylor Law or under the National Labor Relations Act. For public sector employers, this has long been protected under the Taylor Law itself, which prohibits an employer from discouraging or coercing an employee in the exercise of his or her protected activities under the Taylor Law. But now we have an independent right under the New York Labor Law 201D as well. The next slide, please, Kathy. And also in 2023, the law was amended to prohibit discrimination and retaliation against an employee because of their refusal to attend. These are the so-called captive audience speeches or captive audience or communications. So this was added to prohibit or to essentially allow an individual to say, I'm not going to attend a captive audience, what I consider to be a captive audience speech, which is about religious or political communications or matters, or the same thing, have to listen to or watch a communication, a video, for example, which is about religious or political matters. And political matters, as you see here on the slide, is very broad. It includes things like anything relating to elections for political office, political parties, legislation, regulation, and the decision to join or support any political party or political civic community, fraternal or labor organization. I haven't heard of many entities, employers, private or public, providing for these so-called captive audience speeches, but if they arguably involve the employer speaking on matters relating to religion or politics, and again, we have a political season that we're going to be going through over the next few months, you need to be careful if what you're going to do is to hold somebody accountable because they refuse to attend. Doesn't mean you can't do that, right? You can engage in that type of speech if you're an employer, but obviously it's the issue of if somebody chooses not to attend, what are you going to do? Next slide, please. So just to finish up, one of the other pieces that Kristen asked me to cover was for nonprofits, which we have a lot of attendees, a lot of clients, and a lot of attendees on our Tuesday webinar series who are nonprofits in New York. There's a whole host of regulations under federal, New York State, and New York City that regulate lobbying activity generally in New York, but also by lobbying by nonprofits. For example, nonprofits must register and disclose any lobbying activities that exceed $5,000 in a calendar year. So next slide, please. The concern becomes, well, first, let's just cover what is lobbying. It's, again, a very broad definition. Under New York State law, lobbying is defined as any attempt to influence legislation, even the introduction of legislation. So pending legislation, ideas about legislation, anything where the nonprofit is engaged in trying to persuade a legislator or I guess an assistant to a legislator on some form of legislation. Anything related to the agency level too, as well as regulations, actions that have the force of law, procurement, and rate making, including, most importantly, budgeting items. So any type of lobbying that relates to budgeting that may impact the nonprofit is covered by this type of lobbying regulation. Approval of or veto of any legislation by the governor or any types of executive orders, all of those things fall within this type of lobbying regulation. Next slide, please. So what's the important thing? We need to be sure, if you're a nonprofit, that you know and you're aware of when and if and when an employee may be engaged in lobbying or speech activities. So typically a nonprofit who is engaged in lobbying has, secured an outside firm to engage in the lobbying efforts on behalf of the nonprofit, and that's going to be regulated, and you're going to sign up for that. You're going to disclose and register all of those types of things. But when an employee of a nonprofit is engaged in some form of activity that may seem to cover lobbying activity, that's where it becomes problematic for the nonprofit employer. So many nonprofits have policies in place which require that if an employee is engaged in speaking publicly on matters related to legislation, budgets, government state budgets, for example, anything like that, that individual is speaking in his or her personal capacity and is not speaking on behalf of the nonprofit employer. So it's important, make sure you've got that in your lobbying policy. If not, you want to take a look at implementing that or including that in your next draft for your lobbying efforts. That's it, Kristen. Thank you all.
Thanks, Colin.
Sure.
All right, so moving on, Suba is going to talk to us about some record keeping obligations, but moving over to a wage and hour topic here.
Thanks, Kristen. As Kristen said, you could be doing everything right as an employer in terms of paying your employees and giving them the meal periods that they're entitled to. But if you don't have the records to prove that you're in compliance, you're going to have a really tough time defending yourself against litigation, class action litigation, as well as Department of Labor audits. So I'm just going to kind of review best practices for record keeping under both federal and state law. Next slide, please, Kathy. So this is just kind of a list of the general records that have to be kept under federal law for both non-exempt and exempt employees. I'm not going to go through any of these in detail. Next slide, please, Kathy. I'm going to hit upon a couple of records that have to be kept for non-exempt employees. So the regular rate, remember that the regular hourly pay rate includes not just the hourly rate, but also any forms of supplemental compensation that have to be included in the regular rate, such as commissions and non-discretionary bonuses. So if you have non-exempt employees that are receiving those sorts of supplemental payments that have to be included in the regular rate, you have to have a record of those as well as what the regular hourly pay rate is with the inclusion of those supplemental forms of compensation for each work week. The basis on which wages are paid, non-exempt employees don't have to be paid on an hourly basis. But if you choose to pay them on some other type of basis, such as a weekly salary or piecework basis, you have to have a record of the basis upon which they're paid. Hours worked, obviously the best practice in terms of retaining records of hours worked is some form of contemporaneous reporting by the employee. So a time clock where they punch in when they start work and punch out when they finish work, or some sort of electronic record where they're logging into an app when they start and then logging off when they end. Those are obviously the best types of records of hours worked because they demonstrate exactly when somebody started and exactly when somebody finished. You can keep records on a daily or a weekly basis. It's not ideal because I can tell you that most Department of Labor investigators are kind of skeptical when they see a weekly timesheet that shows an employee worked exactly 8:30 to 5 every single day for a 2-year period, and the employee's claiming they worked overtime. The investigator is going to have a little bit of trouble believing that their exact hours were 8:30 to 5 with a 30-minute meal period every single day. So if you can, the best practice is to have some sort of contemporaneous record of hours worked. Next slide, please, Kathy. There are some industry-specific requirements of the Fair Labor Standards Act in terms of record keeping. Tipped employees, if an employer in the hospitality industry uses the tip credit, there has to be some sort of notation that you're using the tip credit, as well as a record of the amount of tips reported by the employee so that you can verify compliance with the tipped minimum wage. If an employee does work in 2 separate occupations, one tipped and one not tipped, those hours worked have to be separated. So an employer has to keep records of how many hours worked in each workday were in an occupation where the employee did receive tips, and how many hours were worked in each workday where an employee did not receive tips. Next slide, please, Kathy. Even if an employer does not use the tip credit, if an employer uses a tip pooling or a tip sharing arrangement, the employer still has to have a record of the weekly or monthly amount of the tips reported by the employees who are part of that tip pooling or tip sharing arrangement. Next slide, please, Kathy. So under New York law, most of the record-keeping obligations are the same as under federal law. There's a couple of different obligations in addition to federal law. One of them is that an employer has to retain the acknowledgements of the Wage Theft Prevention Act forms that are provided to employees. Those are the forms that are prescribed by the Department of Labor that state the wage rate, the overtime wage rate, when the work week begins. Those sign-offs of each employee have to be retained in New York. One other difference is that in New York, employers also have to keep a record of the amount of sick leave provided to each employee to verify compliance with the New York State paid sick leave law. Next slide, please, Kathy. For non-exempt employees, the requirements are really the same as under federal law. You have to keep a record of the regular hourly rate or rates, the overtime rates, the number of regular hours worked, as well as the number of overtime hours worked. Next slide, please, Kathy. Really, for all intents and purposes, employers in New York can kind of ignore the federal retention periods, because under New York law, the statute of limitations for bringing wage claims is 6 years, and the Section 195 of the labor law specifically states that all records have to be retained for a 6-year period. Next slide, please, Kathy. There's no prescribed format for any of these records, as long as it contains the information that's required to be retained. It can be in paper format, it can be in electronic format. The only caveat is that if you get a Department of Labor audit notice, or you're involved in litigation and you have to produce documents in discovery, your records just have to be in a form that can be produced electronically, or at least by converting them to PDF and providing them in PDF format, or printing them out and providing paper copies of those records. One thing that I've run into a couple of times is employers who rely on their third-party payroll providers to maintain records of hours worked and pay payroll records, and they don't retain the records themselves. It does create a problem. You should not rely exclusively on your payroll provider to retain documents. You should also retain a copy, even if electronically. You should retain a copy. If you change payroll providers, it's a problem to try to go back and try to get those records from the providers that you may have had 2 or 3 years ago. So make sure that you're keeping those records and not relying exclusively on payroll providers. Next slide, please, Kathy. I just want to hit very briefly on a specific issue involving meal periods and record keeping of meal periods. Obviously, the best record of you providing employees with their required meal periods is clocking out or clocking back in, or some contemporaneous record that they've taken their meal period. You can theoretically, at the end of a week, have somebody sign off on a written acknowledgement saying that they received their 30-minute meal period for every day that week. That's not quite as good as the contemporaneous record, but it's some evidence that you provided the meal periods. The automatic meal period deductions are probably the most risky way to do this. So if you have somebody, somebody's hours reflect that they worked 8:30 to 5, they don't actually reflect a 30-minute meal period, but you're automatically deducting that 30 minutes per day on the assumption that they've taken their meal period. That can be risky, because the payroll records are going to show, or the time worked records are going to show that they worked 8.5 hours each day, and their pay records are going to show that they worked 8 hours each day. If you're going to have an automatic meal period deduction without reflecting the meal periods on each person's timesheet, you should have a written policy regarding the automatic meal period deductions, a policy that says that everybody has to take their meal periods, provide training for employees on, on taking their meal periods, and provide some sort of procedure for overriding the meal period deduction, and have a record that you've communicated with employees that if they work through their meal periods, that they have, that they're aware of how they can inform their supervisor and get their meal period deduction overridden. Next slide, please, Kathy. The consequences of failure to retain required records, there can be monetary penalties, simply for not keeping the records that you're required to keep. But really, the most serious consequence of not retaining the required records is that a Department of Labor investigator or a court can draw an adverse inference from the fact that you didn't have the records to disprove an employee's claim. And it really kind of shifts the burden of proof to the employer to show that you're in compliance, as opposed to the employee having to prove that you're not in compliance. So that's it for me, Kristen.
Got it. Thanks, Suva. I was a little slow to the unmute there. So thank you very much. So all right, we're running a little short on time, but Nick, you're a good sport. Why don't we go ahead with your presentation today? And if we run a little late, it'll be a little bonus content for folks. So go right ahead. Thank you for being here.
All right, Kristen, thanks for having me. I'll try to be quick. Next slide, please, Kathy. So today's litigation update actually touches on a subject that you may recall me speaking about last year and early this year in the winter, and that's New York's Concealed Carry Improvement Act. So you may recall a couple of years ago, the Supreme Court overturned New York's concealed carry permit program on the basis that its requirement that individuals demonstrate proper cause to obtain a firearm permit was an undue restriction on their right to bear arms. In response to that, on July 1st, 2022, Governor Hochul signed the Concealed Carry Improvement Act, which prohibits individuals from carrying firearms in sensitive locations and restricted areas. Next slide, please. Sensitive locations include government buildings, healthcare facilities, religious institutions, casinos, libraries, public parks, schools, colleges, public transportation, and anywhere licensed to serve alcohol or cannabis. Restricted areas are essentially any piece of private property where the owner had not posted conspicuous signage to indicate that the possession of firearms was allowed. So essentially, in the absence of a sign telling an individual that they could possess a firearm, possession of a firearm would be prohibited under the CCIA. Next slide, please. This law was immediately challenged in federal court on constitutional grounds, and a district court right here in Syracuse granted a temporary restraining order substantially limiting enforcement of the CCIA. It enjoined enforcement of the restrictions on possession of firearm in sensitive locations, including public transport, places of entertainment and amusement, Times Square, and other sensitive locations. It did allow enforcement of the law with respect to the possession of firearms in government buildings, in places of worship or religious observance, except where individuals were charged with carrying firearms to protect the peace. It also allowed for the restriction to go into effect as it applied to schools, colleges, and educational facilities, as well as gatherings of individuals for the purpose of protesting. The district court also enjoined enforcement of the prohibition of firearms in restricted areas. Next slide, please. So that decision was appealed to the Second Circuit. The Second Circuit then reversed the district court's decision in some respects and allowed the prohibition on firearm possession to go into effect with respect to healthcare and drug treatment centers, parks and zoos, bars, theaters, and conference centers. So most of the sensitive locations that the district court enjoined enforcement in. But the court did affirm the district court's injunction on prohibiting the possession of firearms in places of worship and restricted areas. Next slide, please. So shortly after the Second Circuit issued its decision, the Supreme Court issued a decision in a different case, United States v. Rahimi. And that case concerned an individual who was subject to an order of protection due to some domestic violence complaints against him by his partner. While he was subject to that order, he became a suspect in several shootings in the area. Police went to his house, found firearms, and he was ultimately convicted of violating a law that prohibited the possession of firearms by individuals who are subject to domestic violence protective orders. The Fifth Circuit, applying the Supreme Court's decision in Bruin, found that the law was not constitutional because the restriction was not consistent with other historical restrictions on firearm possession. It's worth noting that the Fifth Circuit sits in Texas, so as you might expect, a very different view of Second Amendment law than the Second Circuit we have here in New York. The Fifth Circuit's decision was appealed to the Supreme Court, and the Supreme Court overturned that decision in an 8-1 ruling. It held that courts must decide whether new laws restricting firearm possession are relevantly similar to laws that are traditionally understood to permit applying faithfully the balance struck by the founding generation to modern circumstances, restrictions on firearm possession. So essentially what that means is current restrictions on firearm possession have to be consistent with other historical restrictions on firearm possession. In this case, the Supreme Court held that the law was constitutional because the restriction on possession of firearms by individuals subject to protective orders was consistent with other historical restrictions preventing misuse of firearms. Next slide, please. After Rahimi was decided, the Supreme Court remanded the Antanya case dealing with the Concealed Carry Improvement Act back to the Second Circuit to reconsider its decision in light of the Supreme Court decision in Rahimi. In doing that, however, the Supreme Court does not appear to have vacated the Second Circuit's stay of the district court decision. The New York State Attorney General has commented on that and said the law is still in effect, including the sensitive locations provision, and will be relitigated in the Second Circuit. Next slide, please. So where does that leave us after this extremely complicated procedural history? Well, the number one takeaway, I think, for our purposes is that enforcement of the restriction on restricted areas is still enjoined, meaning there's no prohibition on possessing firearms on private property that doesn't have signs up allowing firearm possession. What that means is that if you're an employer, a business owner, and you'd like to prohibit firearm possession on your premises, you should consider posting signs to communicate to individuals coming onto the property that the possession of firearms is prohibited. Enforcement of the prohibition, though, is still in effect with respect to many sensitive locations. Although importantly, places of worship, the restriction is not applicable there anymore, where individuals are charged with protecting the peace. The court essentially held that churches and other areas of religious observance should have the right to govern firearm possession on their property, just as any other landowner should have. And the only certainty here is that there are going to be more changes, as the New York State Attorney General stated. The issue is going to be relitigated before the Second Circuit. And then, of course, we'll ultimately expect the Supreme Court to weigh in on this issue in the near future. One final caveat I'll throw in there for any public sector employers that might be listening in today. Both the Second Circuit and the District Court do appear to agree, however, that the prohibition on the possession of firearms in government buildings is constitutional. So it's likely that that particular provision will survive review both by the Second Circuit and likely the Supreme Court as well. But again, private property owners, as of now, there is no presumptive prohibition on firearm possession on your property. So if you want to make sure that people aren't bringing firearms into the property, you definitely want to consider putting up signage communicating that firearm possession is prohibited. Thanks, Kristen.
Thanks, Nick. That is quite a litigation saga, and it's not done yet. So we'll see how many more years this takes to get resolved once and for all. And I know you'll be following it. So thank you so much. Thanks all of you for being here today. Appreciate the questions. If there's a couple we didn't get to, we will try to follow up afterwards. Here's the contact info for our presenters, and Gabe will be back next week, and I'll see you later this month. Take care.